Here's the secret. During a consensual encounter, Miranda rights do not exist.
And I know this might seem obvious, but it's so hard to do. Stay calm and do not respond threatening to the officer.
That doesn't mean you have to give them the information that you're looking for. It is perfectly acceptable to say, I'm not answering your questions.
Simply make it clear to them that you're not consenting to them coming in. But if they insist on coming in, stand aside and let them do their thing.
So, what should you do? Or better yet, not do when you get pulled over by the police?
A 5-4 Supreme Court decision just changed the rules for every single traffic stop in America, and almost nobody is talking about it. Right now, as you're watching this, there are thousands of drivers being pulled over, and the vast majority of them are about to make a mistake in the first 15 seconds that no amount of legal help can undo later. I'm not talking about what you say during the stop. I'm not talking about whether you were speeding or had a broken taillight. I'm talking about the moment the officer says those 6 words, "Step out of the vehicle, please," and what you do in the tiny window between hearing that sentence and your foot touching the pavement. That window, those few seconds of decision-making, is where constitutional rights are either preserved or silently surrendered. And after breaking down hundreds of traffic stop cases and the actual case law that governs these encounters, I can tell you with absolute certainty that most people get it completely wrong. Not because they're guilty of anything, but because nobody ever taught them what the law actually requires in that moment. Now, before we get into this, I need to be very clear. Everything you're about to hear is educational analysis. This is not legal advice for your specific situation. Laws vary by state, and if you're facing a legal issue, you need to consult a licensed attorney in your jurisdiction. With that said, let's get into the 5 critical mistakes that could cost you everything during a traffic stop, and I'll give you the exact words to say before you ever reach for that door handle. And I need you to stick around for mistake number 3, because when most people hear it for the first time, their jaw hits the floor. The first mistake: confusing a request with a command. So here's how it usually goes down. The officer walks up to your window, leans in slightly, and says something like, "Hey, can you step out for a second?" And without even thinking about it, you pop the door open and step right out. Seems normal, right? Seems like the cooperative thing to do. But here's what just happened from a legal standpoint. You just voluntarily exited your vehicle. And that word, voluntarily, carries enormous legal weight. Under the 1977 Supreme Court ruling in Pennsylvania versus Mimms, officers absolutely have the authority to order a driver out of a lawfully stopped vehicle. That's settled law, but that authority specifically applies to orders, not requests. When an officer phrases it as a question, "Can you step out?" that's legally a request. And when you comply with a request without clarifying, your exit looks completely consensual on body camera footage. Courts have consistently treated voluntary exits as a form of implied cooperation, which opens the door to broader interactions that follow. So here's the move. Before your hand goes anywhere near that door handle, you calmly and respectfully ask one question. "Officer, are you asking me or ordering me to step out of the vehicle?" That's it. That single sentence forces the officer to put their actual legal authority on the record, captured by their body camera and ideally yours as well. If they say it's a request, you have the right to politely decline. If they confirm it's an order, now you know exactly where you stand legally and you proceed accordingly. You can even follow up with, "And for the record, what is the lawful basis for that order?" The officer either cites officer safety under Mimms or reveals they don't have a clear legal justification. Either way, it's documented. Either way, you now have legal clarity locked into the record before anything else happens. Let me put it simply, never open that door until you know whether you're facing a request or an order. That distinction changes the entire legal trajectory of the encounter. The second mistake: thinking silence automatically protects you. Now here's where things get genuinely infuriating, and honestly they should. Most people believe that if they just stay quiet during a traffic stop, their Fifth Amendment rights are protecting them. That belief is dangerously wrong. In the 2013 case Salinas versus Texas, the Supreme Court ruled that when a person simply goes silent during non-custodial questioning, meaning questioning that happens before any arrest like during a routine traffic stop, without explicitly invoking the Fifth Amendment, prosecutors can actually use that silence against them in court as evidence of guilt. Let that sink in for a moment. Your silence can be used as evidence that you had something to hide. And in Berghuis versus Thompkins from 2010, a suspect sat through nearly 3 hours of interrogation, mostly saying nothing, and then made one brief statement. The court held that he had waived his rights because he never clearly invoked them. The combined rule from these two landmark cases creates a legal reality that feels completely backwards but is absolutely binding. You must speak in order to protect your right to be silent. Silence without explicit invocation is not a shield. It becomes a tool that prosecutors can pick up and use against you at trial. So here's what needs to happen before that door opens. Before your foot ever touches the ground, you say clearly and calmly, "Officer, I am invoking my Fifth Amendment right to remain silent. I do not consent to any searches of my person, my vehicle, or my belongings, and I am requesting to speak with an attorney before answering any questions." 3 sentences, maybe 15 seconds of speaking, but those 15 seconds build an entire legal architecture that gets documented on camera before the stop can escalate. The Fifth Amendment invocation satisfies the requirements of Salinas and Berghuis. The no consent declaration protects you under the Fourth Amendment, because courts look at the totality of circumstances when evaluating consent, and passive compliance has been repeatedly treated as implied permission. And requesting an attorney signals Sixth Amendment awareness and creates a documented record that protects you if things go sideways. Without those words on the record, here's what happens. The officer orders you out. You exit silently. They ask where you're heading tonight. You answer because it seems harmless. One answer leads to another. Before you know it, you've mentioned dinner, maybe a drink, and now the entire nature of the stop has changed. With those words on the record, none of that conversation ever begins. The third mistake, the one nobody sees coming, all right. This is the one I told you about at the beginning, and it catches absolutely everyone off guard the first time they hear it. You've asked whether it's a request or an order, you've invoked your Fifth Amendment rights, you've declared no consent to searches, you've done everything right so far. But there's one more sentence that needs to be on the record before your hand touches that door handle, and without it, there's a gap in your legal protection that most people never even realize exists. Here it is. I am complying with your order under protest, and my hands will remain visible at all times. This single phrase accomplishes 3 critical things simultaneously. First, it establishes on camera that your exit is compelled, not voluntary. Voluntariness is central to how courts evaluate everything that happens after you step out of a vehicle. When your own words document that you exited under compulsion rather than free cooperation, it eliminates the argument that you were willingly participating beyond the legal minimum. Second, the specific words "under protest" function as a legal flag that any reviewing court will immediately recognize. It signals that you were not a willing participant in anything beyond what the law required of you. Third, announcing that your hands will remain visible preemptively eliminates any potential claim of furtive movements, which is one of the most common justifications officers cite for conducting a pat-down search. And here's a detail that virtually no legal content ever mentions. When you step out, close the door behind you. When you exit and leave that door standing open, you dramatically expand what falls under the plain view doctrine established in Horton versus California in 1990. An open door gives officers new angles to observe your vehicle's interior. A flashlight sweep from a lawful position isn't considered a search, it's plain view observation. Anything visible from where the officer is legally standing can be noted and potentially seized without a warrant. Closing your door limits that exposure and forces any further observation of your vehicle's interior to require an independent legal basis. The fourth mistake, talking once you're standing outside. Once you're out of the vehicle, the entire dynamic shifts. You're standing in an exposed environment. Patrol car lights are cycling. Body cameras are recording from multiple angles. And officers are trained to use conversational questions to gather information. How's your night going? Long drive? Where are you coming from? These feel like small talk. They are not small talk. They are investigative tools, and every answer you provide becomes potential material. Under Rodriguez versus United States from 2015, once an officer has completed the tasks directly tied to the traffic infraction, checking your license, registration, insurance, and making a citation decision, the legal justification for your detention is finished. Any continued questioning beyond that point requires independent, reasonable suspicion. And here's the trap. Your own answers are what provide the material to build that suspicion. You mentioned dinner with friends. That leads to a question about drinks. You say just 1 beer. Now you're in a DUI investigation. The officer asks if there's anything illegal in the vehicle. You say no. They say, well, then you won't mind if I take a look. And now you're caught in the consent trap, all because you answered questions you had already invoked your right not to answer. Every question that comes after your invocation gets the same calm, firm, polite response. I have invoked my right to remain silent. No attitude, no sarcasm, no matching aggressive energy. Cooperation does not mean conversation. You can be completely respectful while exercising every constitutional protection available to you. And when you believe the purpose of the stop has been fulfilled, you ask one question on camera. Has the purpose of this stop been completed? Am I free to go? Under Rodriguez, that question forces the officer to either release you or articulate a new legal basis for continuing to hold you. If they have no basis, that failure is now documented. The fifth mistake, failing to execute the first 30 seconds properly. Everything we've talked about comes down to execution in a very small window of time. The first 30 seconds of a traffic stop are the foundation that every subsequent legal protection rests on. Here's the complete protocol. Pull over safely using your turn signal. If it's dark, turn on your dome light, turn off the engine, place both hands on the steering wheel where they're clearly visible. Roll your window down just 2 to 4 inches, enough for document exchange, not enough to create broad visual access to your interior. When asked to provide documents, announce every movement before you make it. I am reaching into my glove box for my registration. My hands will stay visible throughout. Then, before that door opens, your 3 sentences go on the record. First, I invoke my Fifth Amendment right to remain silent, and I do not consent to any searches of my person, my vehicle, or my belongings. Second, officer, are you ordering me to exit, and if so, what is the lawful reason for that order? Third, I am complying with your order under protest, and my hands will remain visible at all times. Then you step out, close the door, stay quiet, and when appropriate, ask, am I free to go? 2 important state-specific notes because general knowledge only takes you so far. In stop and identify states like Texas, Nevada, and Colorado, you are legally required to provide your name when lawfully detained. Refusing can result in a separate obstruction charge. Giving your name in those states is not a rights violation, it's state law. In states like California and Oregon that don't have stop and identify statutes, you have broader protection to decline identification. Regarding marijuana and probable cause, states like Colorado and Maryland have significantly limited the use of marijuana odor alone as a basis for vehicle searches, while in Texas and many southeastern states, that odor still constitutes full probable cause under current case law. Know the specific rules where you live. One final point that ties everything together. Officers are legally permitted to lie to you during a traffic stop. They can claim evidence they don't possess. They can reference witnesses that don't exist. They can tell you that cooperating will make things easier when legally it changes nothing about their authority or your situation. This is precisely why your pre-exit invocation matters so much. Not because you have something to hide, but because you genuinely cannot know what they believe, what they'll claim, or how they'll interpret a single word you say. The only safe response after invoking your rights is silence, followed by one sentence if needed. I invoke my right to remain silent. I want an attorney. Your 4 core phrases one final time. Am I free to leave? I invoke my Fifth Amendment right to remain silent. I do not consent to searches. I want an attorney. Knowledge of the law is not confrontation with the law. It is participation in it. Stay safe, stay respectful, and stay protected. That's it for today, folks. See you in the next video.